skip something. In May of 2008, Ohio Supreme Court Justice Tom Boyer and Governor Ted Strickland, they organized the Ohio's first Summit on Children. 80 of our 88 counties attended this event with teams of 5. And it was a 2-day event. We're following up in November to report back on all of our projects that we decided to take up this year. And as an aside, Lucas County's project is Voices of the Children to increase opportunities for the children to come to court and speak. You know, I watch these children speak in these videos, and it's just awesome to see how resilient they are and what they do, and that they can come and talk to us and give us instruction. And you know, Casey Family Foundation programs does wonderful things with the aging out children. And I know I will speak on behalf of everyone here about how much we appreciate Casey Family programs and the resources and support that you give for all of us here as we do the work that we do. Thank you. So, this is quite an opportunity to spend time with your colleagues, exchanging war stories and telling what's going on in your respective jurisdictions, how you all do it better than everyone else, or the help that you need in sharing information. And it's an opportunity to spend time with people that do what we do, work every day to make important decisions about the family and the children that we serve, and to assist the children and families to make those significant changes in their lives, to create safe and healthy homes for the children, and to achieve permanency for the children in a timely manner. All of this we do in their best interest. And each of us here, we have some of the hardest jobs in the country, no doubt about it. And at the same time, we probably have amongst the most fulfilling jobs in the country. What better word could there be? And using the words of a familiar Peace Corps slogan, it's the hardest job you'll ever love. So, with that said, this is not mine, I'm borrowing it. This is Darren, my assistant. Very good. All right. That look familiar? Each of us who are privileged to work in the court and child welfare system have but one duty: treat each child and family like one's own. When we do that, children and families are respected, assisted, encouraged, and thrived. How humbling to be part of the greatest work there is. Familiar person here, familiar quote. Doesn't it say it all? You know, I met Judge Johnson, he probably doesn't even remember this. It was at a model court conference in 2005. I was a brand new judge, and I was appointed to sit on a panel, to have a panel discussion. And this was a really impressive group of people from across the country in the child welfare biz. So I was a bit anxious, and Judge Johnson was sitting next to me on this panel. And I told him I didn't think I had enough material. So he said, oh, I'd be fine, and he let me borrow his watch to watch his watch. Do you remember this? So he put his watch down, he started, he talked, finished in his allotted period of time, and then it was my turn. So I started talking on this topic that I didn't think I had enough material on. And then I was talking some more, and then I saw the 5-minute sign, the 2-minute sign, and I kept talking, and then I had the 1-minute sign, and I kept talking, and then Judge Johnson started pointing his finger at his watch that was in front of me. And then he pushed the watch over in front of me, and then he nudged me on the side, and then I decided I better stop because I was afraid he was going to take that microphone away from me. So Judge Johnson, I'm going to ask you to be my timekeeper today. All right? Okay. So, mediation and ADR. The key to achieving timely permanency in child protection cases. The key principles of the National Council of Juvenile and Family Court Judges support the use of mediation and alternative dispute resolution, ADR, in child protection matters. And I submit to you that when mediation and ADR are implemented as best practice and endorsed by all stakeholders, this non-adversarial approach becomes an effective tool to achieve timely permanency. Now, Nebraska and Ohio, we sound an awful lot alike, and we're practically neighbors. And we all know when you start a discussion about juvenile justice and child welfare that the language that we use isn't always the same, especially between different states and regionally as well. So I'm just going to take a minute or two and kind of give you a definition of some of the terms that I'm going to use today, the glossary, so to speak. So ADR is alternative dispute resolution, conflict resolution, non-adversarial methods of resolving matters which may become or are within the jurisdiction of the court. And mediation is the process by which a neutral third person, the mediator, assists parties to voluntarily reach a consensual agreement regarding a particular issue or matters in dispute. Child protection matters and cases, I use that term to talk about dependency, neglect, and abuse matters and cases. Agency. The agency in Toledo is the Lucas County Children's Services. It's the agency charged with handling child protection complaints, investigations, and case management during the life of the case. Shelter care hearing, that would be the initial hearing held immediately following the child's removal from parent or guardian. Some jurisdictions call them preliminary protective hearings. Family case conference or staffing. Those are the meetings that are scheduled at the agency at stages of crisis or placement custody, change of placement, review, and permanency planning. A facilitator works with those attending the meeting to come to consensus with the emphasis on the safety threats, protective capabilities and capacities, and child vulnerability. The facilitator makes the decisions when no consensus is reached. Family group decision-making conferences. It's a mouthful. Meeting between the family members and service providers and all others who impact the child's life. It's run by a facilitator with the purpose to exchange the information and devise a plan regarding the custody of the child. Now, the facilitator at certain points during the conference will serve as a mediator at certain stages and sometimes co-mediates as well. So permanent custody motions or complaints, those are actions seeking termination of parental rights. And then the permanent custody stipulated agreement. Sometimes they're called surrenders. The parent's agreement to stipulate to facts surrounding the removal of the child and support of the agency's request for permanent custody or termination of parental rights. So, National Council of Juvenile Family Court Judges, or National Council, as I will be referring throughout this talk, through the work of a committee of highly skilled and distinguished professionals in the area of child welfare, developed resource guidelines, improving court practice in child abuse and neglect cases. That was published in 1995. And then in 2002, adoption and permanency guidelines, improving court practice in child abuse and neglect cases. Now, for those of you who know now that Judge Johnson is the president of National Council and Judge Denise is the president-elect of Council, I will speak for them in endorsing the work of National Council and especially endorsing the guidelines. And I refer to the guidelines regularly in my job, as well as a lot of their materials and their publications. The organization as a whole is a great resource. It's not limited just to attorneys. It's everyone who has anything to do with child welfare cases and matters. And I know that Amari Hall is here, and she has a resource table out there. And I also know that she has a big stack of the resource guidelines. And if I were you, I would be out there and grab a couple up. And she doesn't want to carry them home either, but I use them every day. With that said, the resource guidelines is a compilation of best practice. That is evidence-based research, results-driven practice to implement when addressing a particular issue. I don't know about all of you, but I just don't have enough time in the day or resources available to verify the use and success of certain programs or processes or tools to use to meet our statutory mandates and requirements of child protection cases. In this work, it's too important not to insist on the most efficient and effective ways of handling these cases to achieve timely permanency for these cases. Now, Judge Key was saying today, some people don't like the term best practice. Well, I'll tell you, I don't know about you, watch those kids in that video. Those kids deserve the best. And I think it's important for all of us to insist on the best practice there is out there for these children and families that we serve. Why not? We give our children the best. Why not give them to these kids who are in such need? So, with that said, ADR and mediation are cited in resource guidelines as effective tools to be used in child protection matters. In fact, the key principles underlying resource guidelines and permanency planning for children support use of ADR and mediation. I have those materials in my materials for all of you that's on that awesome flash drive that's hanging on your little strings. So, Lucas County Juvenile Court, we have a court-run mediation department, and we handle a number of different case types in the department. And it includes our dependency, neglect, and abuse, and our termination of parental rights cases. The family group decision-making conferences are run out of the mediation department as well as our mediations. And the family case conferences are run through Lucas County Children's Services, which is our county's, as I said, child protection agency. They have an awesome program, and in my breakout, I have some materials, and maybe I'll talk to you a little bit more about the things that they do in Lucas County in those family case conferences. For example, they're all held off-site, different satellite locations in the community as an example of how they're bringing their services and engaging the families on a more personal basis. Now, although these programs are run through different entities, the participants and the stakeholders are always included in both of the systems. The exception would be for pre-filing if they have a case family conference. You wouldn't have the attorneys there necessarily unless it was a new case, but everyone else is part of that. And I would suggest that the unintended advantage of having the courts and child welfare each oversee a program signifies that both of the programs endorse the use of ADR and mediation as credible vehicles in resolving child protection matters. Now, this leads me to my next proposition, and that is that the importance of having all of the stakeholders endorsing the use of mediation. On my slide, I've included Child Protection Agency, the courts, attorneys, guardian ad litem or CASA, and the community being represented by the service providers, the family support, whatever that would be, and the caregivers, that could be foster parents as well. And it's important to meet with your stakeholders regularly. It's a constant buy-in that creates continuity and integrity. And it needs to be a work in progress. So continuing that relationship with your stakeholders is a guarantee toward positive and productive bond. So from the perspective of child welfare workers and service providers, the court and the family case conferencing at the agency is the very first opportunity that all participants come together in a non-adversarial way to address the issues at hand. That is, the fact that someone has made a complaint about the safety or health or well-being of a child, and that there's reason to believe that some type of agency intervention is necessary. And that when continued intervention is necessary, to review case plan progress when reunification is the goal. Now, the important words in that statement: first, all participants are non-adversarial. Because the agency-initiated conference is the first exposure that the family members are going to have with ADR, it's imperative that this meeting in fact addresses the stated purpose of all parties. It's about creating the opportunity for each participant to raise questions and concerns in a non-threatening environment, focusing on the safety and needs of the child, while exploring avenues for the family to address the problems in a respectful way. Engaging family members and other interested parties can be achieved when the service providers, caseworkers, and others support the process and work cooperatively toward consensus. And then when that's not possible, being respectful and deferring to the facilitator who's going to then have to make a particular decision. Later, when family case conferencing is used at those critical stages, such as placement change, it becomes important to continue to respect all participants in their particular role. And I want to emphasize the respective roles of attorneys, guardians ad litem, and facilitators. To ensure success of the process, all participants must have a clear understanding of the respective roles in the family case conference and then later in mediation. Likewise, the family, and this is important, should understand that their advocate's roles, i.e. their attorney, their roles change depending on the venue. It changes from when they're in the courtroom, when they're in the mediation process, or family case conferencing. And I would suggest that in order to get buy-in for ADR and mediation, the first exposure must be respectful of all participants, must be productive, non-threatening, and meet the stated purpose of the meeting. In other words, if you're going to talk to a family about a placement change, you shouldn't have to spend 10 minutes talking about how this might be a different day and a different conversation if mom had just finished her drug court program. Setting a positive tone and creating a positive outcome creates an opportunity for successful future use if necessary. And so I would suggest that these goals can be achieved in two ways. First, the court must actively sanction the use of ADR, especially when the program is not run by the court. In our court, all child protection cases are screened for mediation. Now, obviously, some cases are going to be screened out of mediation. For example, if the parents' whereabouts are unknown, or if the parents have a violent relationship such that safety can't be guaranteed. Although, as an aside, just because, and I know that there's some differing positions on this topic, but just because a couple have a violent relationship should not, just that fact in and of itself should not be the reason to reject a case for mediation. You know, there are a lot of domestic violence specialists in the community. We have a couple professionals at our mediation department, and all of our mediators have significant training in domestic violence, so that sometimes you can't have a successful mediation when the couples are from a violent relationship. But safety to the parties has to be guaranteed, and you have to be able to have good communication skills to draw that out of one of the parties if they are feeling unsafe, that they would in fact do that. But So just keep that in mind. And I understand that the Nebraska Supreme Court, like the Ohio Supreme Court, actively advocates for ADR. And local court rules requiring the use of mediation and ADR in child protection cases are beneficial. Then it becomes an expectation. Having the court's docket reflect a scheduled mediation or even a group conference or family case conference, it legitimizes the event and it accomplishes the reason that it's on the schedule for a mediation to occur. Now, the use of tools to effectively weed out inappropriate cases for mediation increases the likelihood that there will be productive mediation. And when I became the administrative judge, I made it clear that there would be productive mediations, and the attorneys and the caseworkers and the guardians, they know that because when they accept appointment for the particular cases, we schedule all of their hearings at one time. And if we can't make all of the hearings, and that would include mediation, then I will make and excuse them and appoint someone else. And in our permanent custody cases, I always have a pre-trial after the scheduled mediation. And again, that is to ensure that everyone is acting cooperatively toward our ultimate goal, and that is for permanency. So second, the court can insist upon quality training of all the participants that will participate in mediation. The Ohio Supreme Court mandates training requirements and provides quality training for the mediators. Our jurisdiction has adopted, again, local rules endorsing the standards that have been set by the Supreme Court and requirements with the training requirements, and that is in order to be a mediator in the child protection cases. Our training has a pretty expensive mentoring piece to it, and we have set that up locally. Now, attorneys who serve on our juvenile court appointment list regularly receive training opportunities. It's the least we can do for these attorneys who really don't make any money. We give them free CLE to fulfill their required CLE hours in order for them to be able to take juvenile appointments. We talk about mediation and ADR regularly in those CLEs, as well as the court's CASA and guardian trainings. They are CASA's GALs. They get to observe mediations that they're going to be participating in. So it's through these trainings that issues that can directly impact the credibility and the success of the program, such as cultural competency, development of effective communication skills, poverty barriers, can be addressed in the training setting with the mediators, the attorneys, child welfare representatives, and other participants. And training can assist with diversity recruitment as well. Now, I'm sure many of you in the audience have some additional ways the courts and your respective agencies can assist in promoting ADR and mediation. And I would really suggest that the summit is a good opportunity for all of you to exchange your ideas, and hopefully some of you will come to my breakout session and give me some ideas of what you do in Nebraska to keep your program going. So, I feel like the mother of a valedictorian on graduation day. I've been given bragging rights to talk about Lucas County Juvenile Court's mediation program. Our program has a top-notch reputation statewide and nationally, and our program is featured as a highly regarded mediation program in the Ohio Summit on Children. Our court, when deciding to develop the court-run mediation program, committed to following best practice in its development. And more important than that is the fact that our mediation program is the result of the dedication of many people and organizations in Lucas County that are committed to serving these families to make important changes in their lives so that these children can be safe and happy and healthy and thrive. So I have a short video that I'd like to show you.
When government removes children from their home, parents often feel powerless and intimidated by the mysterious and adversarial legal process before them. Several communities in Ohio have turned to non-adversarial conflict resolution to both resolve child protection cases and invest all parties in a meaningful problem-solving process. The Lucas County Juvenile Court has operated one such program since 1998, and during a recent visit, we spoke with staff, practitioners, and participants about the program.
Now we have a local rule in Lucas County that states that all cases, any petition filed in dependency, neglect, or abuse, or any motion requesting permanent custody or the termination of parental rights, gets screened for appropriateness for mediation. In 2006, we actually mediated approximately 240 temporary custody or dependency, neglect, and abuse cases, and approximately 50 termination of parental rights cases. Parents had a greater sense of involvement in their case and in the development of their case plan services and the future of their children. And in permanent custody cases, we found that parents achieved a closure with dignity when they agreed to terminate their parental rights.
Overall, I'd say it was a good experience. It gave everybody the opportunity to express what they were feeling, get things out on the table with an environment that wasn't hostile, didn't feel threatened at all.
Mediation offers remarkable opportunity for the families to not further become divisive. Trials usually end in what I would say is more friction between the family and the friction level that comes from what is said in court.
Overall, if we look at all the mediations in child protection cases, particularly the temporary custody cases, approximately 75% of those cases overall settled. We also found in our termination of parental rights cases, approximately 50% of the cases settled in mediation.
I definitely believe it was the right decision. Rather than going through an actual court process where people are, you hear this, you don't really feel like you're open to say what you gotta say. It felt like everyone was being honest. My children were definitely the main attention for what it should have been.
When we deal with children, either as an attorney or as a guardian ad litem, there can be no further obligation that is higher in terms of importance. And we are entrusted as professionals, whether we're mediators or the guardians or the attorneys, to handle with care and concern our job. The mediation is where this comes out the best. It shows the best of all of us. And I don't think that we can recreate that in a courtroom. We just are not allowed to because of the adversarial environment. So with respect to a mediation, I welcome every opportunity that I have to attend.
So let's talk a little bit about the value of mediation from three aspects. The first is timeliness, then cost efficiency, and respect for the process and the participants. First, timeliness. ADR and mediation can bring a child to permanency in a timely fashion. Federal and state mandates create important time frames when the state intervenes in families due to child malpractice concerns. And as professionals, each and every one of us should look to the time frames as statutes of limitation as far as I'm concerned, when the children are removed from their homes. I've spent most of my professional career in the area of juvenile law, and more often than not, witness a child being taken into custody from the parent or guardian who's not caring for the child. The children aren't safe, they're hungry, they're not attending school, you name it, and they're crying because they want to go home to their family. And all of us know how strong that bond is. All of us know that it's crucial to correct the reasons for removal so they can go home. And all of us know the value of working efficiently with the family to remedy those reasons for removal. All of us know that when reunification is impossible, that permanency should be achieved in a timely manner. You know, I continually remind attorneys and guardians and caseworkers that 6 months might not seem like a very long time to us, but to an infant, it represents the time it takes to learn to sit up. To a 5-year-old, it represents the time it takes to start reading words. To a 12-year-old, 6 months is the entire baseball season. And for a 16-year-old, in 6 months' time, they can obtain an Ohio, or I don't know about Nebraska, but Ohio driver's license. Mediation and ADR, they bring focus on what needs to be accomplished to accomplish permanency in a productive way. First, the process creates an opportunity to discuss those issues in a safe environment in which the focus is corrective and rehabilitative as opposed to finger pointing and accusatory. And it gives the families the opportunity to participate in the solution. The discussion can focus on problem solving, making the parties part of the solution with the child as the focal point. It's an opportunity for the parties to include additional family members and others to support them and assist them. It's also an opportunity for the parties to ask assistance in a non-judgmental way. For example, admitting to alcohol abuse or relationship with a batterer, or competency issues, mental health concerns, and we all know the list goes on. In other words, the environment should be one in which parties can lay everything out on the table in order to devise a case plan or make changes to a case plan to ensure the child's safety and ability to meet the child's needs, and to take corrective measures to expedite reunification. You know, once a case is filed, I'd suggest that the court-ordered mediation can likewise move cases closer to resolution in a quicker way. First of all, the mediation has a neutral person offering direction in the case, whether it be a discussion about the case plan services or alternate places, or assisting parties to establish stipulated facts for adjudication or disposition, paring down a witness list, and setting up visitation schedules, or creating a schedule for reunification to the parent, or different legal custody, or that difficult discussion regarding termination of parental rights. This process reduces the number of cases that can be resolved by trial. Next, if a case can't be resolved by trial, mediation can pare down the contested issues for trial. In the case of a motion or complaint requesting termination of parental rights, all parties are given the opportunity to voice their concerns and respond to the parents' agencies and the guardian's positions. Again, the atmosphere created is one that gives the parents a neutral, safe environment to listen to the reality of the situation and have that difficult discussion about their future relationship with their children. Now, I call family group decision-making conferences the Cadillac of ADR. It's a type of conflict resolution that has its roots in the New Zealand culture. It's a hybrid of mediation in the sense that the group comes together for the child or the children, and it's extended to all of those who can and are willing to assist the family moving toward permanency, whatever that's going to be. And I'll tell you, it's time-consuming and it is expensive. But I acknowledge that although it may not be cost-expensive from case management perspective, at the same time, it really can be directed toward permanency when there's a sensitive matter that needs to be addressed. And I'm thinking about a case that involved 3 children who were removed from their parents. The parents' rights were terminated. The case was appealed, and it eventually ended up at the Ohio Supreme Court. And the case was reversed. And the children were removed from almost a 4-year placement. Now, as you can imagine, there were a lot of issues that needed to be addressed, including counseling to deal with the removal, support to the parents that were taking custody of the children after this long period, reconciling issues of abandonment, school changes, and on and on. An extensive plan for transition was put in place by agreement of all the parties to that day as a result of the family group decision-making conference. And I submit to you that the potential for disruption in that case was minimized by the fact that all of these parties came together to talk about the best way to transition these children. Now, the length of time it took for this case to go through the Court of Appeals, then that system is a conversation for another day and another time. But also, there was an evaluation, and it's out there actually. I saw it on the table, National Council's table, of the Washington, D.C. Family Court Child Protection Mediation Program. It's really long and technical, but it has some great stuff in it. The evaluators, they've looked at cases for a 24-month period of time, post-filing, to examine the refiling rates. And the study showed that 7% of the mediated cases had a post-closure filing, while 21% of the cases that eventually went to trial returned to court with another petition filed. Now, the next value of ADR mediation is it saves money. We all want to hear about that. Now, we can agree that there are certain cases that are just not they're going to go to hearing, and there is no doubt about it. Maybe it's an uncontrollable client, or maybe there's questions of fact associated with the burden of proof. In other words, can the state or the agency prove its case? So putting those categories of cases aside for a minute, how many times have you been involved in a child protection case at trial and have spent time asking yourself, why is this case going to trial? And the explanation is something like, well, the mother hasn't filed to run her services. Caseworker won't listen to the mother when the mother's trying to explain why she can't make it to her domestic violence group regularly. The father won't admit that he's abusing alcohol, and that's why he isn't going to counseling. The guardian ad litem, well, she stopped listening to everybody because nobody seems to care about the fact that the child is acting out every time mom misses a visit. And if the attorneys would take 2 minutes to return the relatives' calls, maybe we could work something out. Now, I know that you're probably thinking about a trial that was probably 2 or 3 days long before it was all over and was our need. And I will guarantee that that case went up on appeal. So I go crazy over those cases. These are the very cases that could avoid being spun out of control with mediation. It provides the opportunity to open those lines of communication. And as an aside, it's this type of a case that when I hear that the mediation wasn't successful, I'll explore with the parties the possibility of maybe just mediating a single issue. For example, how can we accommodate mom getting to her domestic violence classes so she doesn't miss visitation? So, I have these charts, and I'm not going to go through them because time is moving, and these charts are part of my materials. But this is a comparison of the 2007 and 2008 child protection cases that we handled in our mediation program. DNA means dependency and neglected abuse, and permanent custody or termination cases. So, let's just go from the top to the bottom. You can see that in 2007, of all the cases that were scheduled for mediation, 14% were not resolved in mediation. And then in 2008, 13% were not resolved in mediation. That means all the others were resolved by agreement. And then in the permanent custody cases from 2007 and 2008, when you go down to the bottom, in 2007, 51% of those cases were unresolved. It was a very, very long year in 2007 listening to those trials. And 12 of them, that would be 39%, were unresolved in 2008. And just as a quick aside, You can see the big difference, those jumps in the numbers of filings. In 2008, in the state of Ohio, we are part of a project with alternative or differential resolution of the cases. And to a certain extent, that's what's reflected. It is reflected in those numbers by the big jump. And now looking at the child protection cases and the permanent custody cases, at the bottom line, you can see the average time spent in mediation in these cases, 1.7 hours for the DNA cases and 1.4 hours. Then I asked my court administrator if he could do a cost analysis, because that's all we do today with looking at our budgets. And he was not able to just look at the child protection cases, mostly because I asked him to do it yesterday before I came. But these are all case types. And just to schedule a case for mediation costs $138. And then to mediate it is another $187. Now $325 per case. Now from a case management perspective, when you think about all the docket time opening up and saving the attorney's fees and the guardian's fees and the reduction of appeals, case workers' time in court is reduced. Now, if you look at this, that's a pretty good return on the dollar. So, the last, and as far as I'm concerned, the most important value of ADR and mediation is respect for the process and for all of the participants. No one wants to find themselves in this situation in which they can't take care of themselves or they can't take care of their family, and especially they can't take care of their children. And many times the circumstances that put them in a situation are a direct result of choices that they've made themselves. Many times the situations and conditions of their own upbringing are the direct result of their inability to care for themselves or their children. Mental health, drug dependency, domestic violence, poverty. Each of us have seen it, and we accept these cases for what they are. And all of us in our respective roles are committed to addressing the families, one case at a time, to provide safe and nurturing homes for the children so they can grow and thrive. With that said, ADR and mediation become vehicles for families to face the circumstances they find themselves in, and to become part of the process to create the solutions so that their children can come home. And when the circumstances are such that the logical conclusion based on the facts is to terminate parental rights, it gives the parents an opportunity and a vehicle to make that difficult decision to surrender the children with dignity. Respect for all parties must be the focus at every stage for the very beginning, and it sets the tone for the case. And then it brings me back to my original statement, and that is lead buy-in for the process, founded upon respect for each participant in terms of their particular role, whether at the agency during a case conference, or just prior to a shelter care hearing, or at a permanent custody mediation. It increases the likelihood of success in a particular case, and as part of the entire system of handling child protection matters is added. The respect is absolutely necessary. So, shortly after I took the bench, I had a trial, and it was for termination of parental rights. The mother had stipulated to the agency's request for permanent custody. The father was serving a long prison term with the Ohio Department of Rehabilitation and Correction. The father insisted on being conveyed for trial, and I did do that. So we're at the trial, and you can imagine the testimony. The father was called by the agency, of course, and as you can imagine, the questioning, it was embarrassing, and it was humiliating, it was just plain sad. And during the father's testimony, he turns to me and he says, "Judge, my parents gave me up for adoption, and I never knew why. I just want my girls to know I love them, but I couldn't take care of them." So I called a recess, found a mediator, and the mediation was held in my courtroom. After about an hour and a half, we reconvened and the father entered a stipulated agreement to permanent custody to the agency on the record. And during the mediation, he was able to have a conversation with the caregivers who were interested in adoption. And he got to express to them his feelings and ask them to convey to the children. And they made some arrangements for periodic contact with letters and sending photographs. And, you know, mediation gave this guy the ability to let go of his daughters with dignity. And now, as a result of that, whenever parents are incarcerated, I always convey them for their trial, and I always schedule a mediation just prior to the trial to give them an opportunity just like this man. So, not too long ago, I scheduled a pretrial in a child protection matter. The agency had withdrawn their request for permanent custody, and they were pursuing legal custody to the maternal grandmother. Maybe it's a different term, but we call it legal custody. Now, the father, he was 19 years old. He wasn't visiting his son regularly, and he wasn't following through on his case plan services. He had recently been released from the Ohio Department of Services, his prison, state of Ohio. His mother, so that would be the paternal mother, came to the pretrial with him. She was pitching a fit. She would, and of course it's on the record, accusing Children's Services of her selling her son down the river by denying him his right to raise the child. So a mediation was rescheduled because her son hadn't appeared for the first mediation, and mom had agreed to attend. And all she wanted was for her kid to have a fair shake at raising her son. So what better way to demonstrate respect for the process than by the court's endorsement? In the resource guidelines, there are two practices which I believe speak to respect for the process and the participants. First, every mediation agreement should be in writing, and there should be detail and substance to it. It should also be signed by all the participants. Next, it should be read into the record. It's a local rule for us that it is read into the record, and it is done in the courtroom by the judge or a magistrate. And the procedure has a twofold advantage. First, it gives the court an opportunity to review the agreement right there on the spot. And the participants are there to affirm the accuracy of the agreement. It memorializes the hard work of the participants. And as an aside, when we do a termination of a stipulated agreement for termination of parental rights, we have a mediation form, and that is done in the courtroom in a voir dire, very similar to if you were going to take a plea in a criminal case. And I engage in a lengthy conversation with the parent, explaining them what their rights are, what their status is as a parent in the state of Ohio, let them understand what they're giving up when they are agreeing to this award of permanent custody. And obviously, I talked to them about they have an opportunity to then have another conversation with their attorney. And then I ensure on the record that the agreement is free, knowing, and voluntary. And then, before it is over, this is always the most difficult, and I would say on for everyone, give them an opportunity, and I talk to them about this being in the child's best interest and why they feel that this stipulated agreement is in the child's best interest. And then I always give them the opportunity to place anything on the record that they want about their child or family. Now, you and all, I know that in all likelihood no one is going to read that, it's appeal, but to them, for some reason, it gives them a closure or an ability to kind of just make it right, to explain to the public, so to speak, how they came to where they came to on this day when they were agreeing to this motion. And second, it serves as a reminder for everyone that, this is a court action, And the judge is the one who ultimately is going to make the decision, either through trial or by accepting a partial agreement or a combination of both. So we're getting close to the end, and I just want to talk about two things. The first is confidentiality. You know, it's really insistent that everyone strictly adheres to the rules of confidentiality. It's part of our local rule, and we know there's case law that talks about it, Supreme Court talks about it. But I'll tell you, this information, unless there's an agreement, otherwise, it's not admissible and it's privileged. And if you want a program to lose its credibility quickly, let one of the stakeholders believe that the confidentiality isn't being maintained. And I really think it's incumbent upon the court and all the participants to curtail any breaches of that standard. If somebody starts with, no, this information is not admissible or it's privileged, but you know, during the mediation, it just cannot be acceptable. So, courts should provide mechanisms that can produce an acceptable result in the shortest period of time, timeliness, with the least possible expense, cost efficient, and with the minimum of stress on the participants. This is what justice is all about. That quote, Chief Justice Warren Berger, United States Supreme Court. And I found that after I outlined that part of my speech about the value of mediation. So, I want to make a final note about the kids. We all know that there's discussion nationally and then on the state level that the children who are subjects of child welfare should have a voice in the process, providing information to the courts and giving them feedback. In the state of, you know, this actually, as an aside, this began through a grassroots effort on a number of kids who've aged out of foster care. We thought this was so important. In Ohio, we recently enacted a statute requiring children in care to be given an opportunity to speak to the court in an age-appropriate manner when their placements change. Well, if you have a baby or a 1 or 2 year old, obviously that child isn't going to come to court. That's what guardian ad litem's are for. We have the citizen review boards. That's what we have in Toledo to look at that. But in Lucas County, we have taken this mandate very seriously, and it's been a subject of a lot of discussion. And so, with that said, we give the children an opportunity to participate in the child protection mediation process. I strongly support the proposition. In the materials that I've provided for you, there's some protocols that we use in our mediation department when a child is going to participate. And I would just direct you to refer to that if you're thinking about something like that. And what we do is we have a co-mediator, the child's mediator. This is just a summary, who stays with the child the entire time. And then it's not the child's attorney. The child's attorney is participating as well. But it's that mediator's responsibility to watch the child, talk to the child, make sure that it's productive for the child and that there aren't any problems or going on with the child. It's I think. So as I conclude, I have my contact information, and it's in your materials as well. We have visitors who come across the country and the state to come and see our program. And feel free to come. You have an opportunity to review and observe and exchange information and see these wonderful, dedicated people in Ohio doing just what all of you do every day. And I think we're running out of time, so if you have any questions, I can stick around for a while, or you can come to my breakout session. I did bring from Ohio for anybody who attends. So thank you very much.